Hello, I'm Bob Cox, and this is Cox Notes. Today I have something very special for you. My third great-grandfather came to Colorado shortly after the Civil War. He was a miner, a businessman, and a true patriot. He ultimately founded the town of Florissant in what is now Teller County. And just prior to that, he was one of the first judges in Park County in the territory of Colorado. If you'd like to hear more about that, you can look at my YouTube video on the founding of Florissant, Colorado. I have reenacted various aspects of my third great-grandfather's life, and today I'm once again going to step back in time and invite Judge Castello to address his thoughts on the Constitution of the United States of America, and in particular, the first 10 amendments to that great document. Those 10 amendments became known as the Bill of Rights. Good day. My name is James Castello. Owing to a short stint as Park County judge in the territory of Colorado, I became widely known as Judge Castello. I want to share some things with you today. But first, let's step back in time, to my time. The year is 1876. In just a few short months, Colorado will be admitted to these great United States of America, and the United States will celebrate its 100th birthday. I'm here today to give you my thoughts on one of the most important aspects of my state becoming part of this great union, and what I believe will continue to be the greatest nation on earth. Our founding fathers took a great deal of time putting together the Constitution of these United States that provided for a government, in Abraham Lincoln's words, of the people, by the people, and for the people. In writing this great document, the framers saw the need to amend it and provide assurance that this would be a nation governed by the people and not by an all-encompassing government. With that in mind, they added the first 10 amendments to the Constitution. Those 10 amendments became known as the Bill of Rights. Join me while I express my thoughts on those 10 very important amendments.
The patrons of my trading post in Florissant, Colorado, were known to sit near the stove and play dominoes. When children were present, the dominoes were often placed up on the end and spaced so that pushing down one domino made all the others fall. I think this is a good analogy for the Bill of Rights. If we push over one domino or one amendment, all the others will fail. So let's get started. Amendment 1. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for redress of grievances. This amendment, and all of the Bill of Rights, is intended to limit government. The government cannot tell us to practice a given religion. but we have the responsibility to recognize the rights of others in that regard. The government cannot limit our freedom of speech, but we have the responsibility to exercise that right in such a way as not to cause great harm or prevent others from saying certain things. The old school teaching is that freedom of speech does not mean one can yell fire in a crowded theater. This is a good guidance. Lastly, Amendment 1 provides for petitioning the government for redress of grievances. We have a responsibility to call on the government to correct wrongs. Ignoring this responsibility only encourages abuse of power. We must change laws, not break laws, and that means electing responsible representatives. Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Our first responsibility is to understand this amendment. It's not an accident that Amendment 2 ended up near the top of the list of amendments. The framers of the Constitution and the people they were representing looked upon the abuse of power by the British military as something that could not be allowed to happen in this new nation. At the same time, they knew that a government army or militia would likely become necessary. But in order to prevent that military from becoming what the English military was, they decided to regulate the military or the militia by keeping the citizens armed. Again, this limitation on government is not intended to be a limitation on the people.
Amendment 3. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. When the Bill of Rights was being discussed, this provision was proposed to be part of Amendment 2. It is our responsibility to know why. The chances of this provision being violated by the government are not likely today, but it is not impossible. We must learn the history of the establishment of the United States of America and apply the lessons learned to each of our rights, and analyze the possibility that even one of those rights taken away can and will result in others being taken away. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
Here again, we see that the wording of the first 3 amendments likely led to the founders realizing that further steps must be taken to limit government. There are limitations written into this amendment, and those limitations are directed to government, not to the people. We have the responsibility to learn what those key words in this amendment really mean. Words like unreasonable, probable cause, and particularly describing. These are all limiting words. We must demand that those provisions not be summarily set aside with one phrase like public safety.
Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without the due process of law, nor shall private property be taken for public use without just compensation. Amendment 5 is the most wordy of the Bill of Rights, and consequently will take us a little bit more time here. And it is important to understand and demand that judges, officers of the court, thoroughly understand what is incorporated in this amendment. There are a number of rights and government limitations in these words, and those rights and limitations come to play in both the criminal and the civil process of government action. So let's take a look at some of them one at a time. Grand jury. Well, basically, the framers of the Constitution wanted the government to be limited in criminal cases by putting forth evidence to a grand jury and acting on the jury's findings. In the simplest of terms, that means that the government must establish that a crime has been committed and that the person charged is likely the person who committed that crime. This is and was intended to be a difficult requirement. Double jeopardy. If a person is acquitted of a crime, that person cannot be charged with the same crime again. Pretty self-explanatory. Self-incrimination. This is the part of the amendment that we will likely hear the most about. The government cannot compel a person to testify against himself. Due process. This simply means that if the government is going to deny any citizen of his life, liberty, or property, the government has the responsibility to see that all law is adhered to prior to taking that action. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Pretty self-explanatory. First, the government, or law enforcement if you will, cannot simply arrest a citizen, throw him or her in jail, and leave them there without charging them. They must be able to defend themselves and have a speedy trial. They must know who their accusers are and have a process whereby they, not just the government, a limiting factor again, have subpoena powers, and they must be afforded the assistance of counsel. Amendment 7. In suits of common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. This is a rather unusual statement on the part of our founding fathers. These men were fed up with the way civil trials were held in England and in the colonies controlled by England. They truly believed in a jury trial. We must remember that this applies to the federal courts, but it furthers the idea that the government answers to the people, not the other way around. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. One of the abuses of the English criminal law was often the result of someone being charged with a crime that might not easily be proven. So the enforcers of the law simply arrested and jailed the suspected violator and imposed a bail so unreasonable that it prevented the person from leaving jail. Or, when the person was found to be guilty, especially of a lesser offense, fines would be imposed that were simply not reasonable, or punishment that was cruel or unusual given the facts of the case. And then they were just left in jail. We must remember that in the case of bail especially, it is meant only to ensure that the accused shows up for court. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The last two amendments found in the Bill of Rights basically restates that the government of the United States of America is limited in its powers by the will of the people. Amendment 9 states clearly that just because the framers did not specifically enumerate every right of our citizens does not mean that those rights do not exist. Amendment 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Here again, the framers are saying, just because it isn't specifically stated here in this document does not mean that the people in the individual states are barred from their individual freedoms. And ultimately, the power is with those individual states and with the people.
I must go back to those children playing dominoes at my trading post. If even one of these 10 rights is pushed over, they all will fall. It is unlikely that just one can be removed without affecting the others. We must see to it that our representatives understand that that's what they are, representatives of ours. And we must examine every person whom we're placing in position of rule-making in the government. Thanks for watching. I hope we've stirred some interest. I want to especially thank those young students and teachers who encouraged me to do this video. Those teachers have helped students understand, and I hope they continue to help them understand our history, and especially understand that our history is our future, and you are the future. Please subscribe, and thanks for watching.